how do I get copyright? This comes up a lot. Actually, before I even do that, how many of you are visual artists? Oh, wow, way more this year. Okay, thank you. How many of you are in sculpture? Okay. How many of you are spoken word, literary? Okay. Okay, a little more. What am I missing? Photography? I guess I was dance. Are there a lot of dance? Okay, more photography. Theater. Anything else I'm missing? Like architecture, anything else creative that I may have missed? Okay, all right. So mostly visual arts. Okay. All right, I'll go through all of it. So copyright. A copyright is, the best way to think about it is when you create something, there's really two boxes, right? There's a box with what it is that you've created, and then there's a box with your intellectual property rights. And when I say intellectual property rights, I literally mean that. It's the stuff that comes out of your head that you've created that is now property. It is its own tangible that you stick in this box that you have rights to. You may hand the box over with the thing that you've created, but you don't have to hand the box over with the copyright. It's the best way to think about it. They're two totally separate things. So when you create a picture, you can sell a picture. That doesn't mean that you've sold the copyright. You can keep the copyright. It is a right. It is property. It's something that can be leveraged. It's something that is valuable. So it's really important when we talk about contracts to keep that in mind. As far as when the copyright starts, it's at creation. So you don't have to do anything special. There's no magic words in terms of when the copyright starts. As soon as it's reduced to copyright as an author. However, it's got to be something with a modicum of creativity, right? So it can't just be a replication of writing. Perfect example, recipes are not copyrightable. A lot of people are surprised to hear about that. So you won't see recipes in and of themselves copyrighted because they are not considered to be creative. I know that's a whole philosophical discussion about who gets to say what is creative and not. That is for another time. But as far as it being copyrightable, it is not. Recently, I tried to submit a process for a client because those used to kind of, you could sneak them in as a copyright. They've gotten really stringent, and so we couldn't get it through. What we got copyrighted was the graphic of the process that he wanted to copyright. But we didn't get the process itself because it didn't have enough creativity. So it's got to be something with creativity. It's got to be reduced down into some type of medium in order for it to be copyrightable. Of course, it can be plagiarized. So you can't go around stealing a bunch of people's stuff and then saying, all right, I've put it down into a medium, it's copyrightable. And in terms of what can be copyrighted, it's, again, pictures, music, sounds. A lot of times it's choreography, dramatic works, audiovisual, all of that stuff. So it's got to be some sort of medium. Make sure I'm not missing your questions. As far as what you get with the copyright, before I forget, the best way I can explain that is think about a bundle of straws. So with the copyright comes a couple of straws. It's the right to distribute, it's the right to change, adapt, it's the right to perform, it's the right to reproduce, and the right to display. So there's 6 little straws. You do not have to give all of the straws when you give a copyright or when you give a right. So I can give someone a right to display my work, but I can keep the rest of the straws, which means that they can't adapt it, which means they can't necessarily perform, which means they can't necessarily, whatever the case may be. So it becomes a little tangential when you think of it in your head, but I think if you can reduce it down to something tangible, like the straws, and just keep in mind that it's something that can be played with, that tends to help a lot too. So the 6 bundles you get, it's the right to reproduce, the right to adapt is called adaptation, and so that's changing, modifying it. The right to display, the right to perform. I always miss one. Distribute. Thank you. Someone was listening. And the right to distribute, so passing it out, selling it, etc. And you don't have to give them all at the same time. So in terms of things to do to protect yourself with your copyrights, what I try to explain to people is contracts are absolutely important. They really are, and we're going to talk about in a second why they are so important. But behavior is even more important because contracts are only as helpful as they are if you can enforce them. If you are low on funds and you don't want to pay an attorney to enforce them, they won't do you very much good. So you have to kind of pair that with the way in which you engage with the world when it comes to you guys as arts and works of art, making sure that you don't send everything out, making sure that it's watermarked. One story that I loved is McNally actually prints a error in their maps so that if somebody replicates their maps, they immediately know that it's been stolen. So putting things, I have a good friend of mine with her music, she does that. There's a little blip that's kind of imperceptible, but if she ever had a question, she'd be able to play it back slowly and immediately identify whether or not someone stole some music from her. So when you're sending things out, having the watermarks, doing things like that to protect yourself, but don't send them out in their entirety. Don't send them out to any old body, especially if you're pitching things. And that's pretty much, I don't want to beat a dead horse. In terms of ownership, one thing I did miss, there's some exceptions to copyright. One of them is the works made for hire, which you may have heard about. So there's really two instances where this happens. One is where you're working for someone else, you're an employee, and you create something under the guise of the work that you do for the employer. So it's during work hours, it's with work materials, it's under the scope of your job for that employer. That would likely be a work made for hire, and so you wouldn't have copyright ownership. And usually there's something in your employee manual that will say as much. Another instance is where you're commissioned to do something, especially as part of a larger work. That will probably end up being a work made for hire too. It can range in terms of spectrum, so if you have questions on that, write those down. So, in terms of whether or not it's a work made for hire, it's kind of a facts-based, what the courts would end up doing. So they would look at several of the different facts in the environment, what you were doing, what the expectations were, what the intentions were, to decide whether or not it was a work made for hire, but generally those are going to be the rules. Make sure I didn't miss any of your questions. So one of the questions that was asked before we get off of copyrights was using images of celebrities, poetry, and music, and whether or not that was okay. I think you kind of had that discussion already with fair use. That was going to be my comment, is this a fair use issue? If you're using it creatively, then it likely will not be a fair use. So fair use is a defense. Basically, I can use it as long as there's a fair use of whatever it is that I'm sampling or using or taking a picture of. Usually, for it to be fair use, it's got to be educational or very objective in nature. So like a newscaster is reporting on it, or it's something to do with a teacher. Someone mentioned that when they had students, they teach, and those are fair use. If I am sampling or using something to make it artistic in and of itself, kind of someone mentioned that, the art within the art, that's not usually going to be a fair use. So you're almost always going to want to get permission. The other thing I try to remind my clients of is the tricky thing about IP, intellectual property, is it's very particular in how you have to go about doing it, and it's incredibly vague in how it's interpreted, which means there's no black and white. The only way it's going to get interpreted is in court, and that means you've got to pay for court and an attorney and everything else that's along with that. So cost benefit, it's almost always worth it to just go to the original author and ask, and if they tell you to kick rocks, then you know you are probably going to run into an issue anyway. If they say great and they give you some rules, fine, you figure out what those are and whether it's affordable or not. But chancing it, at the end of the day, determining whether or not you were in the right is going to be something a judge has to do, and I don't know if it's worthwhile for most of you to do that. So keep that in mind. And then another question that came up was clients reproducing your own work. We're going to talk about that a little bit in contracts, but you will want to make sure you have a contract for that. So whoever asked about clients reproducing the work and using it themselves in some regards, you're going to want to make sure to have contract language over that. So, contracts. You really need to have one. They cost so much. It's so much trouble. It's an situation. I get it. So contracts to me are some of the most misunderstood things out there, because really there's a variety of contracts that have existed since woman and man have existed. There's social community contracts. In terms of a written contract, all it really is the same way as when you talk about people who were navigating many, many, many years ago, and they had oral or community contractual relationships amongst themselves. So when it comes to my works of art or it comes to your works of art, how are we going to behave? That's essentially what a contract is. Do you have to have an attorney write a contract? No. Do you have to have a doctor set a broken bone? No. I suggest you have a doctor set a broken bone. the same way that I suggest that you have an attorney write a contract. And I hesitate on saying that because I know that a lot of people are like, well, yeah, you're an attorney, so it kind of helps you to say that. But at the end of the day, I've just seen so many people jack up, either giving their life's work away or, again, jacking up the arrangement, losing out on some serious money because they didn't themselves by at least getting a template. Because a lot of times when I work with artists, they may not start